Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Samia v. United States. In this case, the court considered this issue. Does admitting a co-defendant's redacted out-of-court confession that immediately inculpates a defendant based on context violate the Confrontation Clause of the Sixth Amendment? The case was decided on June 23, 2023. The Supreme Court held that the admission of a non-testifying co-defendant's confession did not violate the Sixth Amendment's Confrontation Clause where the confession as modified did not directly inculpate the defendant, but used the descriptor other person, and the jury was instructed to consider the confession only as to the co-defendant. Justice Clarence Thomas authored the majority opinion of the court. Historically, a non-testifying co-defendant's confession was permissible if the jury was instructed not to consider it against the non-confessing defendant. The court in Bruton v. United States recognized an exception to that general rule, holding that a defendant is deprived of his Sixth Amendment right of confrontation when the facially incriminating confession of a non-testifying co-defendant is introduced at their joint trial, even with a proper instruction. However, the court established certain outer limits on the Bruton rule. For example, in Richardson v. Marsh, the court did not extend the rule to confessions that do not name the defendant. Although in Gray v. Maryland, the court clarified that some redacted confessions might still be directly accusatory if the redaction is evident. Here, the confession was redacted to avoid naming the defendant, aligning with the Bruton rule and differing from the confession in Gray. The court declined to further extend the Bruton rule, reasoning that its extension would disrupt historical practices and necessitate extensive pretrial hearings, potentially leading to mandatory severance in joint trials when introducing a non-testifying co-defendant's confession. This would undermine the role of joint trials and the significance of confessions in the legal system. Justice Amy Coney Barrett joined the majority opinion except the historical discussion, which, in her separate concurrence, she argues is beside the point. She would limit consideration to the meaning of the Confrontation Clause at the time of the founding, and reach the same conclusion. Justice Elena Kagan authored a dissenting opinion, in which Justices Sonia Sotomayor and Ketanji Brown Jackson joined, arguing that the non-testifying co-defendant's confession in this case inculpated the defendant in the same way that the court recognized it would in other cases. Justice Kagan criticized the majority for permitting an end run around the court's precedent and undermining a vital constitutional protection for the accused. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Thomas delivered the opinion of the court. Prosecutors have long tried criminal defendants jointly in cases where the defendants are alleged to have engaged in a common criminal scheme. However, when prosecutors seek to introduce a non-testifying defendant's confession implicating his co-defendants, a constitutional concern may arise. The Confrontation Clause of the Sixth Amendment states that, in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. And, in Bruton v. United States, this court held that a defendant is deprived of his rights under the Confrontation Clause when his non-testifying co-defendant's confession naming him as a participant in the crime is introduced at their joint trial, even if the jury is instructed to consider that confession only against the co-defendant. Here, we must determine whether the Confrontation Clause bars the admission of a non-testifying co-defendant's confession where 1. The confession has been modified to avoid directly identifying the non-confessing co-defendant, and 2. The court offers a limiting instruction that jurors may consider the confession only with respect to the confessing co-defendant. Considering long-standing historical practice, the general presumption that jurors follow their instructions, and the relevant precedents of this court, we conclude that it does not. Petitioner Adam Samia traveled to the Philippines in 2012 to work for crime lord Paul LaRue. While there, LaRue tasked Samia, Joseph Hunter, and Carl Stillwell with killing Catherine Lee, a local real estate broker who LaRue believed had stolen money from him. Lee was found dead shortly thereafter, shot twice in the face at close range. Later that year, LaRue was arrested by the U.S. Drug Enforcement Administration and became a cooperating witness for the government. Hunter, Samia, and Stillwell were arrested thereafter. During a search of Samia's home, law enforcement found a camera containing surveillance photographs of Lee's home, as well as a key to the van in which Lee had been murdered. And, during Stillwell's arrest, law enforcement found a cell phone containing thumbnail images of Lee's dead body. Later, during a post-arrest interview with DEA agents, Stillwell waived his rights under Miranda and gave a confession. Stillwell admitted that he had been in the van when Lee was killed, but he claimed that he was only the driver and that Samia had shot Lee. The government charged all three men in a multi-count indictment. Samia and Stillwell were each charged with conspiracy to commit murder for hire, murder for hire, conspiracy to murder and kidnap in a foreign country, causing death with a firearm during and in relation to a crime of violence, and conspiracy to launder money. Hunter was charged with all but the money laundering count. Thereafter, the government tried all three men jointly in the Southern District of New York. While Hunter and Stillwell admitted that they had participated in the murder, Samia maintained his innocence. Prior to trial, the government moved in limine to admit Stillwell's confession. But because Stillwell would not testify and the full confession inculpated Samia, the government proposed that an agent testify as to the content of Stillwell's confession in a way that eliminated Samia's name, while avoiding any obvious indications of redaction. The district court granted the government's motion but required further alterations to ensure consistency with its understanding of this court's Confrontation Clause precedents, including Bruton. At trial, the government's theory of the case was that Hunter had hired Samia and Stillwell to pose as real estate buyers and visit properties with Lee. The government also sought to prove that Samia, Stillwell, and Lee were in a van that Stillwell was driving when Samia shot Lee. During its case in chief, in accordance with the court's ruling on its motion in limine, the government presented testimony about Stillwell's confession through DEA agent Eric Stouch. Stouch recounted the key portion of Stillwell's confession, implicating Samia as follows. Question: did Stillwell say where the victim was when she was killed? Answer: yes. He described a time when the other person he was with pulled the trigger on that woman in a van that he and Mr. Stillwell was driving. Other portions of Stouch's testimony also used the other person descriptor to refer to someone with whom Stillwell had traveled and lived, and who carried a particular firearm. During Stouch's testimony, the district court instructed the jury that his testimony was admissible only as to Stillwell, and should not be considered as to Samia or Hunter. The district court later provided a similar limiting instruction before the jury began its deliberations. The jury convicted Samia and his co-defendants on all counts, and the district court subsequently denied Samia's post-trial motions. The district court then sentenced Samia to life plus 10 years imprisonment. Samia appealed to the Second Circuit. On appeal, and as relevant here, he argued that the admission of Stillwell's confession, even as altered and with a limiting instruction, was constitutional error because other evidence and statements at trial enabled the jury to immediately infer that the other person described in the confession was Samia himself. He noted that, during opening statements, the government had asserted that Stillwell drove the van while Samia was in the passenger seat, and that Samia pulled out a gun, turned around, aimed carefully and shot Lee. He also pointed out that the government had stated that Stillwell admitted to driving the car while the man he was with turned around and shot Lee. So, even though Samia's position in the van and shooting of Lee were relevant to the government's theory of the case with or without Stillwell's confession, Samia argued that those statements would allow the jury to infer that he was the other person in Stillwell's confession. Samia made the same argument with respect to several pieces of trial evidence. For example, he pointed out that the government had elicited testimony that Samia and Stillwell coordinated their travel to the Philippines and lived together there. Samia noted that there was testimony that he had the type of gun that was used to shoot Lee. And he emphasized that, in its closing argument, the government argued to the jury that video evidence showing Hunter speaking about hiring two men to murder Lee was admissible against all three defendants, allowing the jury to infer that Samia and Stillwell were co-conspirators. Finally, Samia argued that, while discussing Stillwell's confession, the prosecution had recounted how Stillwell described a time when the other person he was with in the Philippines pulled the trigger on that woman in a van that Stillwell was driving. The Second Circuit rejected Samia's view, holding that the admission of Stillwell's confession did not violate Samia's Confrontation Clause rights. Applying circuit precedent, it pointed to the established practice of replacing a defendant's name with a neutral noun or pronoun in a non-testifying co-defendant's confession. The Second Circuit also noted that its inquiry considered the altered confession separate from the other evidence that had been introduced at trial. We granted certiorari to determine whether the admission of Stillwell's altered confession, subject to a limiting instruction, violated Samia's rights under the Confrontation Clause. The Sixth Amendment's Confrontation Clause guarantees the right of a criminal defendant to be confronted with the witnesses against him. As we have explained, this clause forbids the introduction of out-of-court testimonial statements unless the witness is unavailable and the defendant has had the chance to cross-examine the witness previously. Because Stillwell's formal Mirandized confession to authorities, which the government sought to introduce at trial, is testimonial, it falls within the clause's ambit. Nonetheless, the Confrontation Clause applies only to witnesses against the accused, and, ordinarily, a witness whose testimony is introduced at a joint trial is not considered to be a witness against a defendant if the jury is instructed to consider that testimony only against a co-defendant. This general rule is consistent with the text of the clause, historical practice, and the law's reliance on limiting instructions in other contexts. For most of our nation's history, long-standing practice allowed a non-testifying, co-defendant's confession to be admitted in a joint trial so long as the jury was properly instructed not to consider it against the non-confessing defendant. While some courts would omit the defendant's name or substitute a reference to another person or the like, it is unclear whether any courts considered such alterations to be necessary as a categorical matter. In any event, the combination of such alterations and an appropriate limiting instruction was generally sufficient to permit the introduction of such confessions. One early treatise explained that, when some part of a confession concerns other prisoners who are tried on the same indictment, all that can be done is to direct the jury not to take into their consideration such parts as affect the other prisoners. Another noted that, in English practice, where confessions were not admissible against third persons, the names of such persons were by most judges ordered to be omitted, but by other judges the names were ordered read, and the jury instructed not to use the confession against them. In the United States, the latter practice was favored. Considerable authority supports this approach. The court held that, because co-defendant declarations were not, in any view of the case, competent evidence against another defendant, the trial court should have admitted them as evidence only against their respective declarants. In a case involving a joint murder trial of 3 defendants, the court approved the use of a limiting instruction to restrict the jury's consideration of one defendant's incriminatory statements made after the killing had occurred, emphasizing that the trial judge had said, in the presence of the jury, that the declarations would be only evidence against the one defendant. State practice was in accord, permitting the introduction of non-testifying co-defendants' confessions subject only to a limiting instruction. And, though the federal Confrontation Clause did not apply to these proceedings, state constitutions contained similar terms. Notably, none of the early treatises or cases to which the parties have referred, or that we have discovered, suggests that a confession naming a co-defendant must in all cases be edited to refer to another person, or something similar, such that the co-defendant's name is not included in the confession. Accordingly, while it is unclear whether alteration of any kind was necessary, historical practice suggests at least that altering a non-testifying co-defendant's confession not to name the defendant, coupled with a limiting instruction, was enough to permit the introduction of such confessions at least as an evidentiary matter. This historical evidentiary practice is in accord with the law's broader assumption that jurors can be relied upon to follow the trial judge's instructions. Evidence at trial is often admitted for a limited purpose, accompanied by a limiting instruction, and our legal system presumes that jurors will attend closely to the particular language of such instructions in a criminal case, and strive to understand, make sense of, and follow them. The court has presumed, for example, that jurors will follow instructions to consider a defendant's prior conviction only for purposes of a sentence enhancement, and not in determining whether he committed the criminal acts charged. This presumption works in tandem with a defendant's right not to testify against himself, by ensuring that jurors do not draw an adverse inference from his choice not to testify. It also applies to situations with potentially life and death stakes for defendants. A limiting instruction may be used to instruct jurors to consider mitigating evidence for purposes of one defendant and not another at the sentencing stage of a joint capital trial. Of particular relevance here, the presumption that jurors follow limiting instructions applies to statements that are often substantially more credible and inculpatory than a co-defendant's confession. For example, statements elicited from a defendant in violation of Miranda can be used to impeach the defendant's credibility, provided the jury is properly instructed not to consider them as evidence of guilt. Such statements, elicited from the defendant himself, are often some of the most compelling evidence of guilt available to a jury. By contrast, jurors may cast a critical eye on accomplice testimony, and, in particular, self-serving accomplice testimony like Stilwell's that accuses another of the most culpable conduct. The presumption credits jurors by refusing to assume that they are either too ignorant to comprehend, or were too unmindful of their duty to respect, instructions of the court. Moreover, to disregard or to make unnecessary exceptions to it, would make inroads into the entire complex code of criminal evidentiary law, and would threaten other large areas of trial jurisprudence. As explained below, we have no reason to do so here. In a previous case, the court recognized a narrow exception to the presumption that juries follow their instructions, holding that a defendant is deprived of his right of confrontation when the facially incriminating confession of a non-testifying co-defendant is introduced at their joint trial, even with a proper instruction. In another case, the court declined to extend the previous ruling further to confessions that do not name the defendant. Later, the court qualified the previous ruling by holding that certain obviously redacted confessions might be directly accusatory, and thus fall within the rule, even if they did not specifically use a defendant's name. Thus, the court's precedents distinguish between confessions that directly implicate a defendant, and those that do so indirectly. Under these precedents, and consistent with the long-standing historical practice discussed above, the introduction here of Stilwell's altered confession, coupled with a limiting instruction, did not violate the Confrontation Clause. In Bruton, the court considered the joint trial of George Bruton and William Evans for armed postal robbery. During 2 pre-trial interrogations, Evans confessed to a postal inspector that he and Bruton, whom he implicated by name, had committed the robbery. The confession was introduced at trial, coupled with a limiting instruction that it not be used against Bruton. This court held that, because of the substantial risk that the jury, despite instructions to the contrary, looked to the incriminating extrajudicial statements in determining Bruton's guilt, admission of Evans' confession in this joint trial violated Bruton's right of cross-examination secured by the Confrontation Clause of the Sixth Amendment. The court acknowledged that a defendant is entitled to a fair trial but not a perfect one, and conceded that it is not unreasonable to conclude that in many cases the jury can and will follow the trial judge's instructions to disregard certain information. It even acknowledged that, if it were true that the jury disregarded the reference to Bruton, no question would arise under the Confrontation Clause. Yet, the court reasoned that there are some contexts in which the risk that the jury will not, or cannot, follow instructions is so great, and the consequences of failure so vital to the defendant, that the practical and human limitations of the jury system cannot be ignored. Accordingly, in the court's view, the introduction of Evans' confession posed a substantial threat to Bruton's right to confront the witnesses against him. Later, in Richardson, the court declined to expand the Bruton rule to a redacted confession that inculpated the defendant only when viewed in conjunction with other evidence. There, Clarissa Marsh, Benjamin Williams, and Kareem Martin were each charged with assault and murder. Marsh and Williams were tried jointly for the crime. And, at trial, the state introduced Williams' confession, taken by police shortly after his arrest. As introduced, however, the confession was redacted to omit all reference to Marsh. Indeed, to omit all indication that anyone other than Martin and Williams participated in the crime. The confession largely corroborated the victim's testimony, and additionally described a conversation between Williams and Martin as they drove to the scene of the crime. According to Williams, Martin said that he would have to kill the victims after the robbery. Following the confession's admission, the trial judge instructed the jury not to use it against Marsh in any way, an instruction reiterated in the jury charge at the conclusion of trial. In her testimony, however, Marsh volunteered that, during the drive to the crime scene, she knew that Martin and Williams were talking but could not hear the conversation because the radio was on and the speaker was right in her ear. Both Marsh and Williams were convicted. In considering the introduction of Williams' confession, this court noted that, ordinarily, a witness whose testimony is introduced at a joint trial is not considered to be a witness against a defendant if the jury is instructed to consider that testimony only against a co-defendant, emphasizing the almost invariable assumption of the law that jurors follow their instructions. It then explained that Bruton represented a narrow exception to this principle. Whereas the confession in Bruton had expressly implicated the defendant and his accomplice, the confession in Richardson was not incriminating on its face, and became so only when linked with evidence introduced later at trial. The former evidence, the court explained, is more vivid and thus more difficult to thrust out of mind. Additionally, in the case of inferential incrimination, the court posited that the judge's instruction may well be successful in dissuading the jury from entering onto the path of inference, leaving no incrimination to forget. Gray then confronted a question Richardson expressly left open: whether a confession altered by substituting for the defendant's name in the confession a blank space, or the word deleted violated the Confrontation Clause. In Gray, the court considered Anthony Bell's confession to Baltimore police, implicating himself, Kevin Gray, and co-conspirator Jacqueline Van Landingham in a murder. The prosecution sought to introduce the confession at trial, and the trial judge required that it be redacted to use the word deleted or deletion whenever Gray's or Van Landingham's names appeared. At trial, the prosecution had a police detective read the confession aloud to the jury verbatim, substituting the words deleted or deletion for Gray's or Van Landingham's names. Immediately after the detective finished reading the confession, the prosecutor asked, "After he gave you that information, you subsequently were able to arrest Mr. Kevin Gray, is that correct?" The officer responded, "That's correct." In instructing the jury at the close of trial, the judge specified that Bell's confession was evidence only against Bell, admonishing the jury not to use the confession as evidence against Gray. The jury convicted Bell and Gray. This court held that the confession was inadmissible under Bruton. It first noted that, unlike Richardson's redacted confession, Bell's confession referred directly to the existence of the non-confessing defendant. The court then concluded that, when a redacted confession simply replaces a name with an obvious blank space, or a word such as deleted or a symbol or other similarly obvious indications of alteration, the evidence so closely resembles Bruton's unredacted statements that the law must require the same result. The court reasoned that such obvious blanks would cause the jurors to speculate as to whom the omitted individual may be, lifting their eyes to the non-confessing defendant, sitting at counsel table, to find what will seem the obvious answer, as the judge's instruction will provide an obvious reason for the blank. It also reasoned that statements redacted to leave a blank or some other similarly obvious alteration were directly accusatory, pointing directly to the defendant in a manner similar to Evans' use of Bruton's name or to a testifying co-defendant's accusatory finger. While the court conceded that Richardson placed outside the scope of Bruton's rule those statements that incriminate inferentially, it explained that inference pure and simple cannot make the critical difference, for if it did, then Richardson would also place outside Bruton's scope confessions that use shortened first names, nicknames, and descriptions as unique as the red-haired, bearded, one-eyed man with a limp. The court elaborated. That being so, Richardson must depend in significant part upon the kind of, not the simple fact of, inference. Richardson's inferences involve statements that did not refer directly to the defendant himself, and which became incriminating only when linked with evidence introduced later at trial. The inferences at issue here involve statements that, despite redaction, obviously refer directly to someone, often obviously the defendant, and which involve inferences that a jury ordinarily could make immediately, even were the confession the very first item introduced at trial. Finally, the court stressed that its holding, which addressed only obviously redacted confessions, was sufficiently narrow to avoid unnecessarily leading prosecutors to abandon the relevant confession or joint trial. Viewed together, the court's precedents distinguish between confessions that directly implicate a defendant and those that do so indirectly. Richardson explicitly declined to extend Bruton's narrow exception to the presumption that jurors follow their instructions beyond those confessions that occupy the former category. Gray qualified but confirmed this legal standard, reiterating that the Bruton rule applies only to directly accusatory incriminating statements, as distinct from those that do not refer directly to the defendant, and become incriminating only when linked with evidence introduced later at trial. Accordingly, neither Bruton, Richardson nor Gray provides license to fly-spec trial transcripts in search of evidence that could give rise to a collateral inference that the defendant had been named in an altered confession. Here, the district court's admission of Stillwell's confession, accompanied by a limiting instruction, did not run afoul of this court's precedents. Stillwell's confession was redacted to avoid naming Samia, satisfying Bruton's rule. And it was not obviously redacted in a manner resembling the confession in Gray. The neutral references to some other person were not akin to an obvious blank or the word deleted. In fact, the redacted confession is strikingly similar to a hypothetical modified confession we looked upon favorably in Gray, where we posited that, instead of saying me, deleted, and a few other guys, the witness could easily have said me and a few other guys. Accordingly, it falls outside the narrow exception Bruton created. Moreover, it would not have been feasible to further modify Stillwell's confession to make it appear, as in Richardson, that he had acted alone. Stillwell was charged with conspiracy and did not confess to shooting Lee. Consequently, the evidence of coordination between Stillwell and Lee's killer, whether Samia or not, was necessary to prove an essential element of the government's case. In addition, editing the statement to exclude mention of the other person may have made it seem as though Stillwell and Lee were alone in the van at the time Lee was shot. Such a scenario may have led the jurors, who sat in judgment of both Samia and Stillwell, to conclude that Stillwell was the shooter, an obviously prejudicial result. As described above, expanding the Bruton rule in the way Samia proposes would be inconsistent with long-standing practice and our precedents. It would also work an unnecessary and imprudent change in law, resulting in precisely the practical effects that the court rejected in Richardson. The Confrontation Clause rule that Samia proposes would require federal and state trial courts to conduct extensive pretrial hearings to determine whether the jury could infer from the government's case in its entirety that the defendant had been named in an altered confession. That approach would be burdensome and far from foolproof, and we decline to endorse it. Indeed, it would be impractical to fully police juror inferences in the way Samia seems to suggest. In a criminal trial, all evidence that supports the prosecution's theory of the case is, to some extent, mutually reinforcing. Thus, the likely practical consequence of Samia's position would be to mandate severance whenever the prosecution wishes to introduce the confession of a non-testifying co-defendant in a joint trial. But, as this court has observed, that is too high a price to pay. Joint trials have long played a vital role in the criminal justice system, preserving government resources and allowing victims to avoid repeatedly reliving trauma. Further, joint trials encourage consistent verdicts and enable more accurate assessments of relative culpability. Also, separate trials randomly favor the last tried defendants who have the advantage of knowing the prosecution's case beforehand. Samia offers, as an alternative, that the government may choose to forego use of the confession entirely, thereby avoiding the need for severance. But this ignores the fact that confessions are essential to society's compelling interest in finding, convicting, and punishing those who violate the law. And, as described above, Samia's proposal is not compelled by the Confrontation Clause. The Confrontation Clause ensures that defendants have the opportunity to confront witnesses against them, but it does not provide a freestanding guarantee against the risk of potential prejudice that may arise inferentially in a joint trial. Here, the clause was not violated by the admission of a non-testifying co-defendant's confession that did not directly inculpate the defendant, and was subject to a proper limiting instruction. We therefore affirm the judgment of the Court of Appeals. It is so ordered. Justice Barrett, concurring in part and concurring in the judgment. I agree that the admission of Stilwell's modified confession, together with a limiting instruction, did not violate the Confrontation Clause. But in my view, the historical evidence described in Part 2A is beside the point. First is a timing problem. The evidence is largely from the late 19th and early 20th centuries, far too late to inform the meaning of the Confrontation Clause at the time of the founding. The court seems to agree, because it does not suggest that the history is probative of original meaning, but nor does it explain why this seemingly random time period matters. For whatever reason, the parties only speculate. There appears to be little founding-era evidence illustrating how courts handled the admission of a co-defendant's confession. So why not simply say that the history is inconclusive? And if we are going to pick up the thread in 1878, why drop it in 1896? Are cases from 1896 that much more important than cases from, say, the 1940s? While the court makes a claim about long-standing practice for most of our nation's history, it describes only a snapshot. That brings me to my second problem, the substance of the snapshot. The cited cases address the rules of evidence rather than the Confrontation Clause. On top of that, the two federal cases do not discuss the effectiveness of limiting instructions, much less any need for redaction. Sparf v. United States holds that the co-conspirator exception to the hearsay rule does not apply to statements made after the conspiracy has ended. Emphasizing the trial court's error in admitting the statements against both defendants, the court explained that the trial court should have admitted them against the speaker and excluded them against his co-defendant. Neither limiting instructions nor redaction came up. United States v. Ball is similarly tangential to Samia's case. There, the court held that the trial court had not abused its discretion in trying three co-defendants together. As support for that point, the court noted that when the government introduced the admissions of one defendant, the trial court at once said, in the presence of the jury, that of course it would be only evidence against him if he said anything, and the court was not afterwards requested to make any further ruling upon this point. The court assumed in passing that the limiting instruction was effective, but the co-defendants did not argue otherwise, and they did not ask the court to alter the statements. The two state cases at least address and endorse the use of a limiting instruction after the admission of a co-defendant's confession. State v. Workman, Jones v. Commonwealth. One even holds that a trial court should not alter a statement by redacting a co-defendant's name. Like the federal cases though, the state cases make no mention of the confrontation right. Same for the treatises cited by the court. So for all we know, the cases cited by the court and the treatises proceed from the premise that an ordinary hearsay rule, as opposed to a constitutional right, was on the line. That weakens the importance of these sources, because courts might have gone to greater lengths, for example, redaction, to ensure that a jury did not consider a declaration whose admission would violate the state or federal constitution. Bruton v. United States, after all, grounds itself in the Sixth Amendment. At best, the evidence recounted in Part 2A shows that, during a narrow historical period, some courts assumed, and others expressly held, that a limiting instruction sufficiently protected a co-defendant from a declaration inadmissible on hearsay grounds. In suggesting anything more, the court overclaims. That is unfortunate. While history is often important and sometimes dispositive, we should be discriminating in its use. Otherwise, we risk undermining the force of historical arguments when they matter most. Justice Kagan, with whom Justice Sotomayor and Justice Jackson join, dissenting. Imagine a criminal case involving two defendants, John and Mary. John and Mary are arrested for robbing Bill. Before trial, John confesses to the robbery in an interview with police. But John does more than admit his own involvement. He also points a finger at Mary. John says to the police, "Mary and I went out Saturday night and robbed Bill." Mary, on the other hand, confesses to the robbery. She maintains that she wasn't involved. In fact, that she never left her home on the night in question. The government tries John and Mary together. At trial, it introduces a copy of John's confession into evidence, and has it read to the jury by the interviewing officer. But John elects not to take the stand, leaving Mary's attorney without an opportunity to cross-examine him about his confession. This court's precedent bars the government from using John's confession in that way. The Confrontation Clause of the Sixth Amendment guarantees a criminal defendant the right to be confronted with the witnesses against her, which includes the right to cross-examine those witnesses. So when two defendants are tried jointly, the pre-trial confession of one identifying the other as involved in the crime cannot be admitted unless the confessing defendant takes the stand. That is true? We held in Bruton v. United States, regardless of whether a judge instructs the jury to consider the evidence only against the confessor, John, and not against his co-defendant, Mary. Even with that kind of instruction, a substantial risk exists that the jury will impermissibly rely on John's confession when determining Mary's guilt. Suppose, though, that the government redacts the confession to eliminate Mary's name. Mary still sits in the courtroom alongside John, but the version of the confession admitted into evidence now includes a blank space where Mary's name belongs. And when the interviewing officer reads the confession to the jury, he says deleted in place of Mary's name. So instead of Mary and I went out Saturday night and robbed Bill, what the jury hears is deleted, and I went out Saturday night and robbed Bill. That confession, too, is inadmissible under our precedent. Though the confession no longer identifies Mary by name, the implication is obvious. A juror need only lift his eyes to Mary, sitting at counsel table, to realize to whom deleted refers. The redacted confession thus presents the same risk as the unredacted one, that the jury will consider it as evidence against Mary even if instructed not to. Because the confessions so closely resemble each other, we have held, the law must require the same result. Now consider one last option. The government again modifies the confession to avoid the express reference, but this time, instead of swapping Mary's name out for deleted, the government replaces it with the words a woman. The line read to the jury thus becomes, a woman and I went out Saturday night and robbed Bill. In the face of precedent that would bar the government from using either of the first two versions of John's confession, a judge must decide what to do about this one. Would its admission too violate Mary's right of confrontation? The answer should be obvious. A jury is still going to recognize that John is talking about Mary, for who else could the mystery woman be? This last version of the confession thus presents the same risk as the first two, that jurors will rely on John's confession when assessing Mary's guilt. Yet in today's decision, the court draws a line of constitutional significance between the first two examples and the third. Confessions that use a defendant's name or a symbol of omission, clear Confrontation Clause violation. Confessions that replace a defendant's name with another placeholder, no Sixth Amendment problem, no matter how obvious the reference to the defendant. In so elevating form over substance, the majority permits an end run around our precedent and undermines a vital constitutional protection for the accused. Start with Bruton, the foundation of this court's precedent on the introduction of confessions at joint trials. The government, we held in that case, cannot introduce a confession by a non-testifying defendant that names a co-defendant as an accomplice. Admitting the confession against the co-defendant would violate her Sixth Amendment right to cross-examine witnesses. And an instruction to the jury to disregard the confession when assessing the co-defendant's guilt cannot remove the constitutional problem. That is because of the effect that such a powerfully incriminating extrajudicial statement is likely to have on a jury. In this context, the risk that the jury will not, or cannot, follow the instruction is so great, and the consequences of failure so vital to the defendant, that the practical and human limitations of the jury system cannot be ignored. The Bruton rule applies even when an accusatory confession does not expressly name the co-defendant. Bruton, we have held, bars the use of confessions that replace a name with an obvious blank space or symbol or word such as deleted. So the Bruton rule extends beyond the first John and Mary hypothetical to the second. And similarly, Bruton bars the admission of confessions that use shortened first names, nicknames and descriptions as unique as the red-haired, bearded, one-eyed man with a limp. The court assumed, for example, that at a joint trial of 4 defendants, 3 black, 1 white, Bruton required the exclusion of 2 of the black defendants' confessions because they referred to the white guy as a participant in the crime. Though confessions of that kind do not expressly name a non-confessing defendant, they still point directly at him. They thus raise the same constitutional concern, that jurors will consider the confession's accusation in evaluating the non-confessing defendant's guilt. Until today, Bruton's application turned on the effect a confession is likely to have on the jury, as a comparison of 2 of our decisions shows. In Richardson v. Marsh, we approved the admission of a confession redacted to eliminate not only a co-defendant's name, but any reference to his or her existence. Despite that complete redaction, the confession served to incriminate the co-defendant later in the trial, when her own testimony placed her in a car ride that the confession described. But we thought that a confession that incriminated only by connection with subsequent evidence was neither so vivid nor so powerful as a confession that incriminated on its face. For that reason, we thought the jury was more likely to obey the instruction to disregard the confession as to the co-defendant. But we held in gray that the calculus is different when a confession refers directly to the existence of the non-confessing defendant, even though not by name. Such a confession itself points a finger at a co-defendant, so that the jury can immediately and vividly grasp how it implicates her. The impact is so similar to naming the defendant that the law must require the same result. In both situations, the confession's powerfully incriminating effect creates a special, and vital, need for cross-examination, just as if the co-defendant pointed directly to the defendant in the courtroom. Consider against that backdrop the facts of this case. Petitioner Adam Samia was tried jointly with two co-defendants, Joseph Hunter and Carl David Stillwell, on charges related to a murder committed in the Philippines. According to the prosecution's theory of the case, Paul LaRue, the head of a transnational criminal organization, ordered the killing, and Hunter, one of LaRue's managers, hired Samia and Stillwell as hitmen. Before trial, Stillwell confessed to federal agents that both he and Samia were present at the murder, but told them that Samia was the triggerman. On that version of events, Samia shot the victim in a van that Stillwell was driving. At trial, one of the agents testified about Stillwell's confession, replacing Samia's name with placeholders like somebody else and the other person. So, for example, when the prosecutor asked the agent what Stillwell had said about his arrival in the Philippines, the agent answered, he stated that he had met somebody else over there. And when asked whether Stillwell had recounted the crime, the agent testified yes. He described a time when the other person he was with pulled the trigger on that woman in a van that he and Mr. Stillwell was driving. From the jury's perspective, the identity of the triggerman would have been obvious. The jury knew from the start of trial that there were just 3 defendants. It knew based on the prosecutor's opening statement that those defendants were on trial for offenses related to a death in the Philippines, and it knew the role that each defendant allegedly played in the crime. Hunter had hired Stillwell and Samia as hitmen, and those 2 men carried out the murder. In fact, the prosecutor began his opening statement with the exact sequence of events Stillwell had described in his interview. The prosecutor told jurors that Samia shot the victim twice in the face, while the victim was riding in the back seat of a van driven by Stillwell. So when the federal agent took the stand on day 2 of the trial, it didn't make a lick of difference that he didn't identify the shooter by name, but instead used placeholder terms. Any reasonable juror would have realized immediately, and without reference to any other evidence, that the other person who pulled the trigger was Samia. That fact makes Stillwell's confession inadmissible under our Bruton precedent. The agent's testimony about the confession pointed a finger straight at Samia, no less than if the agent had used Samia's name or called him deleted. So how does the majority reach a contrary result? The nomenclature it adopts isn't the problem. In describing Bruton's scope, the majority distinguishes between confessions that directly implicate a defendant and those that do so indirectly. That distinction roughly tracks the one this court has recognized between confessions that themselves incriminate a co-defendant, directly implicate, and those that become incriminating only when linked with later introduced evidence, indirectly implicate. But the majority distorts that distinction beyond recognition when applying it to the facts of this case. In one blink and you miss it paragraph of analysis, the majority holds that Stillwell's confession does not directly implicate Samia for 2 reasons. It was redacted to avoid naming Samia, and the redaction was not akin to an obvious blank or the word deleted. That analysis altogether fails to capture what our Bruton cases care about. This court has already made clear that the first fact relied on, that Stillwell's confession did not use Samia's name, is not dispositive. A confession redacted with a blank space, after all, also avoids naming the defendant. Yet Gray held that it falls within Bruton's scope. So today's decision must rest on the second feature of the confession, that the placeholder used, for example, the other person, was neither a blank space nor the word deleted. But that distinction makes nonsense of the Bruton rule. Bruton's application has always turned on a confession's inculpatory impact. And as the John and Mary examples make clear, a confession that swaps in a phrase like the other person for a defendant's name may incriminate just as powerfully as one that swaps in a blank space. So the majority warps our Bruton precedent by categorically putting the 2 on opposite sides of the constitutional line. As the court remarked in another case about Bruton, the law cannot command respect if we apply such inexplicable and indeed unprincipled line drawing to a constitutional imperative. Contrary to the majority's claim, Gray repudiates rather than supports the distinction adopted today. In holding that Bruton's protections extend beyond confessions with names to confessions with blanks, Gray explained that what should matter is not a confession's form but its effects. A jury, Gray noted, will often react similarly to the 2 kinds of confessions. The blank space, rather than name, is not likely to fool anyone. Ignoring Gray's forest for one tree, the majority points to a passage in which the court described how a confession in the case could have been further redacted. Instead of saying me, deleted, and a few other guys, the witness could have said me and a few other guys. But on Gray's particular facts, the latter version was unproblematic. The crime was a gang assault involving 6 perpetrators, while only 1 other person was on trial with the confessing defendant. The me and a few other guys phrase thus did not point a finger directly at the co-defendant, as the other person phrase here did at Samia. The more relevant reference discussed in Gray was to the white guy in a trial with only 1 white defendant, as described above. Gray left no doubt that the confession with that phrase should have been excluded, and for the same reason as the confession with deleted. When a modified confession has an accusatory effect similar to one with names, the court reasoned, the law requires the same result. Gray could not have cared less whether the modification takes the form of a blank space or of a different, but no less accusatory placeholder. The practical concerns the majority cites in support of its decision are equally flimsy. On the majority's view, a ruling for Samia would require courts to conduct extensive pretrial hearings reviewing the government's case in its entirety. But that charge is a straw man, and one that Gray already knocked down. The Bruton rule, whether applying to confessions with names, with blanks, or with other placeholders, demands only that a court consider in advance of trial such matters as the content of the confession, the number of defendants, and the prosecution's general theory of the case. Courts have long considered those basic factors when applying Bruton, and the government has proved unable to cite a single case, including in circuits applying Bruton to confessions like Stilwell's, in which doing so created administrability issues, much less fewer joint trials. In any event, greater convenience in the administration of the law, as Bruton noted, cannot come at the expense of fundamental principles of constitutional liberty. That price, we recognize then, is too high. With nothing else to support it, the majority reaches for two props inconsistent with Bruton itself. One is the presumption that jurors follow limiting instructions. The majority correctly describes that presumption. It just forgets that the presumption does not apply when the evidence at issue is an accusatory codefendant confession. Bruton could not have been clearer on the point. We cannot accept limiting instructions as an adequate substitute for a defendant's constitutional right of cross-examination. And the majority does know better in invoking historical evidentiary practice. One point here is Justice Barrett's. There just isn't much history helping the majority. But assume for a moment to the contrary. Suppose with the majority that at some relevant time, courts conducting joint trials admitted unredacted codefendant confessions subject only to limiting instructions. If that history controlled, Bruton itself would have been wrongly decided. The majority's real views thus come into focus. The point of its opinion is not to distinguish the confession here from the one in Bruton. The point is to say why Bruton should go. And so one might wonder after reading today's decision whether Bruton is the next precedent on this court's chopping block. The one reason it may not be is that there is now no need for formal overruling. Under this decision, prosecutors can always circumvent Bruton's protections. Consider once more John's confession implicating Mary in a robbery. A confession, I'll now add, bearing a striking resemblance to the one in Bruton. The Bruton rule will still bar the prosecution from using the original version of John's confession, expressly naming Mary. So too the rule will prevent the prosecution from swapping out Mary's name for a blank space, or the word deleted. But no worries, the government now has a functionally equivalent placeholder at its, court-sanctioned, disposal. It can simply replace Mary's name with a woman, and the Bruton issue will go away. But contrary to today's decision, the serious Sixth Amendment problem remains. Now, defendants in joint trials will not have the chance to confront some of the most damaging witnesses against them, and a constitutional right once guaranteeing that opportunity will no longer. It will become, in joint trials, a shell of its former self. I respectfully dissent. Justice Jackson, dissenting. I join Justice Kagan's dissent in full and agree, in particular with her insight that the majority's bottom-line view is that Bruton should go. I am writing to emphasize that most of the force of the court's argument, to the extent that it is at all forceful, comes from the majority, having improperly reframed the constitutional standard that applies to the admission of incriminating testimonial statements of a co-defendant during a joint criminal trial. Under the majority's approach, the default rule is that a non-testifying co-defendant's incriminating confession is admissible, so long as it is accompanied by a limiting instruction. Thus, for present purposes, the majority repeatedly calls Bruton a narrow exception to this default rule, and the thrust of the majority's holding is that the so-called Bruton exception is, and must be, narrow. Bruton is a pesky deviation that requires the exclusion of otherwise admissible evidence. That approach inverts the constitutional principles that govern this case. Under our well-established Sixth Amendment precedents, the court's analysis must start from the premise that the introduction of Stilwell's inculpatory confession during the joint trial threatened Samia's Confrontation Clause rights. The introduction of a testimonial statement from an unavailable declarant violates the Confrontation Clause, unless the defendant had a prior opportunity for cross-examination. Here, there is no dispute that Stilwell's statement to law enforcement was testimonial, that Stilwell was an unavailable declarant, and that Samia had no opportunity to cross-examine Stilwell. Therefore, the default presumption in this case should have been that Stilwell's confession was not admissible at his and Samia's joint trial, because the statement implicated Samia on its face, and Samia could not cross-examine the declarant. When the government attempted to nonetheless introduce Stilwell's inculpatory confession notwithstanding Samia's inability to cross-examine him, it sought an exception from the Confrontation Clause's exclusion mandate. Before today, this court had never held that a limiting instruction, combined with a redaction that merely replaces the defendant's name, sufficiently cures the constitutional problem. In Bruton, the court rejected the idea of an exception entirely. It entertained permitting such an exception in light of a limiting instruction given at trial, but the court ultimately declined to adopt one. Then, in Gray, the government tried again to get an exception to the Confrontation Clause, this time adding an obvious redaction of the defendant's name in the confession on top of the limiting instruction, but this court once again rebuffed such efforts. Indeed, the only prior case in which this court has permitted an exception to the baseline confrontation rule of exclusion was one in which the confession at issue arguably was not even against the defendant in the first place, as it did not incriminate the accused in any way until the defendant herself introduced evidence that rendered the confession inculpatory. Collectively, our precedents properly recognize the necessary narrowness of any exception to the default Bruton principle that the government's introduction of an inculpatory confession during a joint trial poses a substantial constitutional problem. Not anymore? With today's ruling, the majority fails to acknowledge what is the default rule and what is the exception, and it thereby sets the stage for considerable erosion of the Confrontation Clause right that Bruton protects. Properly understood, the Bruton question actually raises two distinct issues, one about whether there is a Confrontation Clause problem in the first place, and a second about potential cures, like redactions and limiting instructions, for that constitutional dilemma. The majority skips over the first question today. Its analysis essentially assumes that there is no Sixth Amendment problem in the first place, which then allows for an unwarranted expansion of what should be a narrow exception to the default principle of exclusion. In other words, the court has now turned our Bruton cases on their head in a manner that risks undermining a core Sixth Amendment right. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.